Justin, after you make your initial filing with the US Patent and Trademark Office, let's say they come back and reject that filing or give you some level of pushback that, let's say, the filing was improper in some way, or maybe they need some additional information. What should you then do in response to that?
Sure. So keep in mind that whenever we make a filing with the U.S. Patent and Trademark Office, so let's take trademark registrations. That's the one most people are familiar with. There's this own tension because you're trying to get as much as you can, but you're also trying not to get so much that it just gets rejected out of hand. And so we toe this line, and a lot of times, and probably in most applications, you'll get some sort of communication back from the USPTO. Sometimes it's a minor thing, like if you put an address that's like a UPS store, you're going to get flagged, and they're going to ask for the real address. Not a big deal. A call to the examiner can resolve that, or if you want to keep your real address secret, then you have to submit it electronically. Other times they may come back and say, look, this description of goods and services you provided is just too broad. And that's an okay. I mean, I prefer those kinds of objections, because then you're going to get as close as you can to the line, because they're going to pare it back just a little bit, as opposed to putting in something really, really narrow that may go right through, but maybe you could have got that description a little bit broader. So there are lots of different reasons they'll push back. You have to respond. If you don't respond, your application goes abandoned, and then the whole thing's over. So I guess I should actually like rephrase that. You don't have to respond, but if you want to get a registration, you have to respond.
Mm-hmm.
So then there are some other ones though that are more challenging. So sometimes the trademark office will come back and say, look, there's already a registration that's similar to what you're trying to register, and they'll refuse you on those grounds. And those types of refusals get more challenging, because the trademark office has a policy that only one trademark for a similar set of goods and services can be registered at any given time. And there are exceptions, but if you get that type of refusal, then you really have to sit down and decide, okay, am I going to try to fight this? Is there another way that I can get around this refusal? But again, you have to respond, or otherwise your application will go abandoned. And typically these days you get a 3-month response period that can be extended by 3 months. You pay them some money and they'll extend it 3 months. So that's what you have to do, is you have to, you get these notices that come by email, and you have to respond to them if you want to keep your application.